In the medical field, malpractice is when a healthcare professional fails to act in a way that other, similarly trained healthcare professionals would in a given situation. Physicians are often seen as the leaders of medical teams, and therefore are often the named defendants in malpractice cases. In order to provide great patient care and avoid malpractice, physicians must be aware of what is expected of them in the eyes of the law. One reason that physicians are sued is called a failure to diagnose, which is when a physician is judged to have not diagnosed a condition that they had ample opportunity to. For example, if a 50-year-old female patient comes into the doctor's office because of a newly discovered breast lump, it is reasonable to expect that a physician would examine the lump and order a mammogram. If this doesn't occur, a malpractice suit may be filed once the patient is finally diagnosed. The medical record is also a legal record. If a patient chooses to not have recommended testing performed, the physician should have the patient sign an informed refusal document. On a similar note, all communication between healthcare providers about patients should take place within the medical record. This includes using integrated texting or internal messaging functions within the electronic medical record. As another example, imagine the physician didn't initially recommend further investigation of the mass in this patient. A year later, the mass is significantly bigger and a mammogram is finally ordered. This is called a delay in diagnosis. In this, or any situation, the medical record should never be retroactively changed, unless it is done by inserting an addendum with a clear explanation for why the addendum was included. Electronic medical records track metadata that shows when a medical record was accessed and by whom. When healthcare providers learn that a suit has been filed against them, it is recommended that they do not access the patient's chart. It can look like an attempt to change the notes to deceive the court. Contacting a risk management department, your professional liability carrier, and/or hiring a lawyer can help start the process of legal protection. While there are many different reasons why a patient may file a suit against a doctor, perhaps none is more important than patient anger. If a patient outwardly expresses anger, it may be an expression of helplessness or sadness, so it's important to listen and try to understand the root of the patient's feelings. On a similar note, it can be tempting to offer a refund for services rendered as a form of apology to the patient. However, it should be clarified with the organization's risk management department, your professional liability carrier, or your defense attorney as to whether or not this is allowed. Alright, as a quick recap. Malpractice is when a healthcare professional fails to act in a way that other, similarly trained healthcare professionals would in a given situation. Some common reasons that providers are sued include a failure to diagnose, a failure to treat, and the cause of unintended patient injury. Patient anger often plays a predominant role in cases, so it's important to listen and try to understand the root of the patient's feelings. For more information on this topic or Coverys, email riskmanagement@coverys.com or visit coverys.com.